lots of people joining at the moment. So we will be looking to get started today. So for those of you who don't know me, my name's Hannah, and I'm a member of the team here at Bhayani. I've been here for coming up to 5 years now, and we've been running these HR exchanges for some time. So I'm sure lots of you will have been on these things before. But for those of you that it is your first time, welcome. Hopefully you'll find this interesting and very helpful. And as we go through, as I say, if there's any issues, any questions, anything at all, please drop a message in the chat box. I've got a couple of colleagues who are also on the call that will be monitoring the chat box and should hopefully be able to help you out if there are any issues. So, first of all, a bit about us. As we say, most of you, I think, on here, there are a lot of our clients that we speak to regularly. So, hello. And then there will be some people, as I say, that we've not spoken to before, but this is just a little bit about Bhayani Law, who we are, what we do. We are a law firm, but we specialise in employment law and HR advice. So hopefully cover both sides of the coin. A little bit more about us, as I say, you will get a copy of these slides. You do fill out the feedback form so you can have a look at all of these things yourself, but they're quite interesting. Any questions throughout, please, as I say, pop them in the chat box. I will aim to answer as many as we can whilst we're on the webinar today. But if we do run out of time, please just make a note of your question and then you can email it to hello@bhayanilaw.co.uk and we'll get back to you as soon as possible. But as I say, equally, that will be the email address in terms of feedback forms and things like that. So that's where you need to send any correspondence if you've got any questions, or if you just come off the call today and think, oh, actually, that would be something that would be really helpful to know, drop us an email and I will look to get back to you as soon as I can. And hopefully we can get all of those questions bottomed out for everybody. But yeah, in the first instance, please do drop them in the chat box and we'll see what we have time for. So what we will be covering today, generally, as I say, redundancies, what we expect from employers, what the tribunal expects from employers in relation to redundancies, what a redundancy is, how to manage that process and other exit processes effectively. So we'll also be touching on some other routes of exit ultimately, how to stay compliant and ensure that you're doing everything that you need to be doing and hopefully in the best possible way all round for the business and for the employees that are going through that process. How to maintain employee well-being during a redundancy exercise, and practical tools to navigate these situations with confidence. Ideally, we want everybody on this call coming away and thinking, right, okay, this is not going to be an easy process, but I know what I'm doing. And it's going to be something that maybe even with a little bit more help from Bhayani Law, we will be able to do safely and in the best possible way for our staff. Because we all know, whether you've been directly affected by a redundancy situation, whether you've had to run a redundancy situation, or whether, as I say, you've been a part of it in some other way, it's not pleasant generally. It's generally considered a bit of a no-fault dismissal. It's not that you've done anything wrong. It is just circumstantial, and unfortunately, one of those things that we are seeing become a lot more prevalent at the moment. A lot of employers are thinking about it in the near future, or they're having to already go through this process. So it is something definitely on everybody's radar. And I think we could see that with the amount of participants we've had sign up today. It's clearly something that people are concerned about and wanting to know more information about. So as I say, hopefully we'll answer some of those questions for you today. So we'll get straight in. What employers should be aware of when they're considering redundancies. So the headlines, really, we're going to cover what redundancy means, when employers must inform and consult about redundancy and what consultation looks like, what is a reasonable consultation process, how to deal fairly with employees being considered for redundancy to minimise claims of unfair dismissal, which is ultimately my job really today, to ensure that none of these processes, or as little as possible, are going to end up in any kind of tribunal claim, whether that be through discrimination or ultimately an unfair dismissal. Because redundancy is a dismissal. There are 5 potentially fair reasons that you can dismiss somebody, and redundancy is one of them. So whilst I think it's quite common that people say, oh, it's a redundancy, we're not sacking them, they've not been fired, they've been made redundant, it is still a dismissal. and it still has the same risks associated with it if you were to dismiss somebody for gross misconduct or for capability. As I say, it is a little bit, it can be considered a no-fault dismissal, and people can accept a redundancy dismissal much easier often than a capability or a misconduct dismissal, because they see it as it's not my fault. They don't take it as personally. So it may not result in as many claims, but there are still processes that you must go through in order to ensure that you are dismissing somebody by way of redundancy fairly, and that will not result in an unfair dismissal claim at the employment tribunal. We're also going to look at alternatives to redundancy. So rather than jumping straight through to we need to get rid of people, it's too expensive, what are the other alternatives? Could we be looking at layoff clauses, short-time working? What does your contract allow for? And if it currently doesn't allow for any of these things, do we need to look at amending our contracts, potentially for any new starts and moving forward? We are looking at alternatives to redundancy in much greater depth at our annual conference that will be happening on the 13th of March 2025. So only in a couple of weeks' time. We're having it's similar sessions to what we do in terms of our HR exchange, but it's what we do as a yearly roundup, essentially. What are all the big changes you need to know? And the topic of our annual conference this year is on cost saving and alternatives to redundancy. What does a fair redundancy look like? But are there ways we can avoid that? Are there other things that we can be doing to ensure that we're keeping our staff happy, we're keeping them efficient, and ultimately we are not going to be losing more than we're making, which is the point of business, really. So that might be something, if you are interested in this topic, in alternatives to redundancy, or looking at a more in-depth discussion around this topic, definitely keep an eye out for our conference, as I say, that is happening in March. Watertight clients, I believe you do get a discounted ticket, but there are also early bird tickets available right now. They are only for a limited time only at a reduced cost. So if you are interested in those, as I say, the details will be in these slides later on. But also, if you needed to get in touch with us, give us a call or drop us an email and we can give you some more information about that. So we'll also cover very quickly how to determine the employee's entitlement to statutory or contractual redundancy pay. So before we're even looking at making people redundant, how much will that cost? How much are they going to get in terms of that compensation payment when they are made redundant? Because that's going to be a really key factor in your decision making as to whether redundancies are necessary and appropriate. So the redundancy process generally, these are the kind of key 5 points that we'd break it down to. We need to, first of all, identify which employees are affected to determine the selection pool. So are we looking at everybody? We need to make every single department, run in a more efficient manner. And is that then going to result in redundancies? Is that the correct route to go down? Are we looking at one area? Have you lost a major contract or a major piece of work that this specific team of people were working with, and therefore we don't need as many people working in that area? What is the reason you're considering redundancies in the first place? The key thing really with this, and the key thing, if nothing else, I would like everybody to go away with today, when you are looking at making redundancies, we need to be focused on the job roles. So we're not looking at the individual people. We're not looking at Dave and that he turns up late 3 days a week, so we might want to make him redundant. We're not looking at the people. We're looking at the jobs, because it is the role that would be made redundant, not the people. And that's going to make a little bit more sense when we go through the selection criteria later on. But generally, the role is redundant. It's not, as I say, due to your personal attributes. It may come down to that ultimately when we are looking at the selection criteria. And that is where we move on to the second section here of defining what that selection criteria looks like. We would always recommend that this is done before you undertake the process. So it's very clear that's been predetermined what this selection criteria will be before we start involving individuals and how it will apply to them. We don't want it in any capacity to look that it's been, constructed in a certain way to aim for certain people. And there are ways and means of, we need to make sure that it is fairly balanced by objective and subjective criteria, and we will discuss that and what that will look like. But we need to make sure that that selection criteria is very clear from the get-go, so everybody knows what everybody's being assessed against when their role is at risk. We need to ascertain if collective redundancy consultation is necessary. So how many people generally are we making redundant and over what time period? What that consultation looks like. So if it is collective, what does it look like? If it's not a collective consultation, what does that look like? And what does a consultation meeting consist of? And then ultimately the compensation. So what will an employee look to receive if they are made redundant? And how much is that going to cost the business ultimately? So the definition of redundancy is three types of situations ultimately. There's a full business closure. So, generally, if the whole business is closing down, it's probably a redundancy situation because no job is required moving forward. Every job within the business is redundant, and every employee with more than 2 years service will be eligible for a redundancy payment as compensation for that loss. There is no alternative role for them to do because the whole business is closing. That's a pretty straightforward, this is a redundancy situation. If there's a workplace closure, so what we mean by that is, for example, you have 5 offices: Sheffield, Doncaster, Barnsley, Rotherham, and Leeds, and you're closing the Leeds office. That workplace is closing, but there are other offices, potentially other alternative roles, potentially other people doing exactly what they do in Leeds, but in Barnsley and in Rotherham, and we're only going to be looking at those roles being at risk. That's when we would consider, are there any alternatives and are they suitable in alternative workplaces? We're not carrying out business in that place, but we may be continuing business elsewhere. So that's going to be a little bit more of an in-depth consultation process. Or probably the most common one that we're seeing at the moment is a reduction of the workforce. So the business is remaining to trade, in every department is going to continue in the way that it runs, but instead of 4 people in that team, we only need 2. And there's going to be a reduction there. So there's been a reduced requirement for the employees to carry out work of that particular kind, and therefore there's a reduced requirement for all the employees that are currently employed in that area. Okay, I think that's the one that we can maybe see quite easily. We're all doing lots of work. There's now not as much work for everybody to do, so there might be a couple of afternoons where people are sat twiddling their thumbs, and it becomes clear that there is not enough work for all the people in that team, and therefore there may be risks of redundancies if we are reducing that team. So, initial considerations for the employers. So, what we would always recommend with all of our clients is to plan. We need to map it out. We need to have a sit down and real think about, as I say, is redundancy the right option? Are we jumping the gun? Are we going straight for, we'll just make them redundant and thinking that's the easy way out? Or are we actually looking at the organizational structure, the business rationale? What is the proposal? What are we aiming for at the end of this? So ultimately, we need to consider what the current structure looks like, what that business case is for a redundancy. So has there been a catalyst? Have we lost a major contract? Is there something that's happened that has resulted in this downturn of work? Is it just that we've been going along for so long at a certain level and that is unsustainable? What is then the proposed structure? So where are we currently and where are we proposing we move to? And therefore, how many employees is that going to affect? There may be some departments that are completely unaffected. They run as lean as they possibly can. There is no way there's going to be room for anything else or any change in that department. They're going to be left alone, potentially. So we really need to sit down and think about what roles and therefore how many employees are going to be put at risk. It's certainly worth considering if you have a redundancy policy. It's not necessarily a statutory requirement for people to have one, but if there is one in existence, it certainly needs to be consulted at the very least. If you do have one, but you've not seen it for some time, or you think it might need some updating, definitely have a look at that sooner rather than later, because you don't want to be changing and amending policies halfway through the process. It doesn't look good. You need details of any trade union or collective agreements. Is there an agreement in place that is going to impact this consultation process? Are there other people we need to speak to and consult with? Definitely get ahead of that to understand the time frame of how long that may take. You'd also then look at which employees are at risk and what is their length of service. If you've got a couple of people who are midway through their probationary period, are we looking at redundancies in total, or is it just going to be a case of, unfortunately, this is being brought to an end and we're not going to be replacing that role because actually we don't need it. Definitely look at the employees. Similarly, if you've got every employee that's at risk there that has got 15, 20 years service, can the business afford to make this number of redundancies? As I say, are we jumping the gun straight to making them redundant, thinking that's going to be cost saving when it very much may not be, dependent upon the employee's specific criteria? Are there any redeployment opportunities available? So, if we have identified the members of staff that are at risk, is there anywhere else it would be suitable for them to work? Did they used to work in that department and would they be up for moving to that department again? Do they have the skills? Do they have the experience? Are we asking them to move to a different office that's actually 60 miles away? And that's just not going to be possible. There are lots of different things to consider, and it may be that you can consider them initially, but as the consultation process goes on, they still remain fluid and live. So if you are having a consultation meeting with employees that are at risk, and you've in your brain ruled out the idea that they could move to that office that's 60 miles away, there is a job there, you're advertising for it, but it's not something they're going to consider. You still need to give them the opportunity. They very well may have been considering a move, or they wouldn't mind the commute because they can work remotely for 2 days a week. It's definitely worth raising it as an option, not necessarily this is a suitable alternative and you're going to be placed there if it isn't suitable, but something to consider and allow the employee to also to consider. And if they do raise it, it may then change the outcome of their consultation. And it's something, as I say, that the consultation period needs to remain fluid in line with other people raising different issues. You do need to also ascertain what the employee's notice periods are. Is their contractual notice more than their statutory notice? Are there any pile-on clauses in there? Do you have any garden leave clauses? Will you want people to work their notice? Will you not? These are all things that need to be considered prior to undertaking this process, so you know what rights you have, what rights employees have, and how that's going to look moving forward. And similarly, are you going to put everybody on garden leave? Are you going to pay everybody pile on, or is everybody going to work their notice? Or is that going to be applied differently dependent upon the person and the job role? Who is going to lead and who will support on the project? So generally, if you are undertaking a mass consultation, a mass redundancy across a number of different departments, there may be heads of department that are going to run the consultation process within each department. It may be that one person is going to run the whole thing. If you have a senior HR manager who's going to run the consultation with everybody, it may be that it's only a small number. What does that look like? Who is that person or number of people? Have they been trained appropriately? Do they know how to have a consultation meeting and are they comfortable doing that? Do they feel confident going in that they're going to be able to run that meeting efficiently and also with the lowest level of risk? If something really goes south, are they prepared? Have you got the relevant people in these roles who will be able to undertake the process, but also document the process? Because that's going to be really, really important moving forward, that you have enough documentation to clearly evidence the consultation process and all the planning that went into it. Because there's no point considering all of these things, making sure you have a thorough, in-depth plan if we're then going to go into consultation and the managers or the leaders who are running these meetings have not been involved with any of that, don't really know what the new structure is going to be, don't know what the business case is for the redundancies, and can't answer any questions or have any kind of meaningful consultation. It's all going to be a waste of time. So we need to ensure that these people are included and you have the knowledge and the confidence to go into these consultation meetings. So, as I say, consultation really must be undertaken with a view to reaching an agreement. And the agreement may be, yes, I understand there is no role here. This role has diminished, and therefore I accept that, it is redundancy. I saw this coming. If you can avoid the need to make redundancies as part of the consultation, that is a further aim. So a meaningful consultation would be listening to what the employee is raising. So it may be that full well going into this meeting, there's nothing they can say that's going to change the outcome of this, unfortunately. We are where we are. And it's a very unfortunate position that this is the case. But the employee may have ideas that you've not considered. They may bring up certain requirements or considerations that it's worth going away and thinking about. And I would always recommend that if there is anything raised that you've not previously considered in these consultation meetings, that you're completely honest and say, I haven't considered that. I really appreciate you bringing it to my attention. I am going to go away and think about it, and I'm going to discuss that with the team. Discuss it, and it may be that it comes to nothing, but the employee feels listened to and that they've been heard. And also, you're evidencing that this is a meaningful consultation. It's not just a tick box exercise. You are understanding that there are other alternatives. And, we're all human. Ultimately, one person isn't going to have all the answers. And the point of the consultation is to listen to the employees' concerns or questions and give them the opportunity, as I say, to look at other alternatives or avoiding dismissals. It may be that they've undertaken studying outside of work time to upskill themselves in other areas. So they may want to apply for other alternative roles within the business. Each consultation process or consultation meeting ultimately is going to be slightly different. So there's going to be no opportunity really where I can say, this is what a perfect consultation meeting looks like, and this is what you should say, because you have to be receptive to these other things being raised. But as long as you are evidencing to the employee that you are listening and that it is a meaningful consultation to the point of a backwards and forwards conversation rather than this is happening, like it or lump it, there you go, you're going to be in a much better position, and the employees are going to feel much less aggrieved and potentially reduce the number of appeals or tribunal claims ultimately that are going to come as a result of these dismissals. So, consultation. As we mentioned before, there is a collective consultation or there is individual consultation. So, if you are within a 3-month period making 20 people or more redundant, then it is likely this will constitute as a collective consultation. It's collective redundancy. So, that comes with additional obligations. If you do think that you're going to need support or you have any questions around collective consultation, I would absolutely recommend that you get in touch with us directly. You need to contact one of our HR advisors or somebody within our team at the legal team, and we will be able to guide you through that, because there are a number of steps and obligations that are much, much more than you would need to do if you are looking at 19 or less redundancies. So within that number, 19 or less, there is no minimum consultation period. So when people say to me, well, how long must the consultation period last? Do I need it to last 3 months? Do I need it to last 2 weeks? Is one meeting enough? There's nothing set in law that states for less than 19 redundancies, the consultation period must last this amount of time. So what we would recommend, and what it does state, is that it must be a reasonable consultation period. Now, that may look different in different circumstances and to different people. So, reasonable really would be, in my opinion, at least 2 meetings for the consultation period. So, give them the opportunity in the initial meeting to ask any questions, to raise any concerns that they have, and then have some time before the second consultation meeting so that the employee is able to really process what's been said, and come back to you if they do have any follow-ups, but also allow for you to come back to them with any follow-ups if they have raised things that you'd not yet considered. You need time to go away and think about that and speak to people and see whether it is a viable option as an alternative to redundancy. So, as I say, it needs to be at least one meeting, a private meeting with that individual, so per person, unless you do have a policy or a contract that says you're going to hold more. But as I say, at least one, I would recommend two, really, to evidence that you have had a reasonable and meaningful consultation process. It may be that you have more. It may be that somebody doesn't want more than that. They understand, they're quite happy that that is what's happening and they're going to take their redundancy. They don't need to ask any further questions. But it's going to be on a case by case basis that will be assessed. So if you are trying to plan or make a kind of timeline of this is how long we think, if we're looking at 19 or less redundancies, then as I say, I would hold at least one or two, if not three, per person meetings. So as I say, the main requirements of a consultation process, you're providing the affected employees with written information. So I know a lot of our clients may have seen some of the letters that we can provide in this respect. So it'll be outlining what the proposal is, what the business case is, who's at risk, the proposed selection criteria, any information in relation to their welfare and their well-being. You know, do you have private healthcare? They offer maybe a counselling session. You know, it can be quite a scary time for a lot of people if they're unsure of the future of their employment. So you may also want to put in there, this is something, you know, we can signpost you to assistance in this way. It's not a legal requirement as it is to outline the proposals as part of the consultation process. I would also, within the consultation, explain what the consultation is, what the purpose of it is, what is going to be discussed in that meeting. You may be dealing with employees that have never had a formal process like this before, and it can feel a little bit overwhelming. So again, you can just explain that the consultation is mainly for their benefit, for them to ask any questions, for them to raise any different alternatives, and for them to have a discussion with you about this proposal. It gives employees the opportunity to fully understand the matter, keep an open mind, and as I say, be willing to be persuaded. They may raise issues that you've just not even considered as a possibility. So definitely don't go in there with a closed mind. So as I say, this is kind of a breakdown generally of what a consultation process can look like. It doesn't have to, and they all will look different. But as a step by step, really, you'd set out the decision of why you're proposing to make redundancies, any alternatives that you've already considered. So you can say, you know, we did consider this, we considered this, but unfortunately that's not going to be possible because of X, Y, and Z. You unfortunately are at risk, so you can confirm to the employee that they are at risk. This bit is really crucial within the consultation. So we need to inform employees that they are at risk, but because the consultation process is so fluid and can result in the avoidance of redundancies, no formal decision has been made at this point, and that needs to be very clearly communicated to the employees that are placed at risk. If you're going in the very first consultation meeting and saying, yeah, look, you're redundant, sorry, we're going to look at see if there's anything else we can do, but you're redundant. There's not really anything we can do. That is not going to constitute a meaningful consultation. It's going to look premeditated and clearly that there is no listening ear within that consultation. You've made up your mind, you've made your decision, and that it is what it is. Ultimately, the consultation process, as I say, needs to be a two-way street. So it needs to be made very clear that you're currently at risk, your role is at risk of being made redundant. However, we are looking at these alternatives, we're doing what we can. This is your opportunity to raise any other alternatives or ways that we can avoid your redundancy. And we're receptive to that. So there's no formal decision until the end of the consultation process. You also, you know, generally employees' first question when they're told they're at risk is, okay, how much am I going to get? How much is my redundancy going to look like? As I say, we can discuss what that would look like, but generally you would set out to the employee what your redundancy payment would be. So is it just a statutory redundancy, or do you have contractual redundancy obligations? Do they have any holiday owed? Because that will be paid upon termination. And then what does their notice period look like? Is that notice period contractual, statutory? Will it be paid in lieu? Will they be working their notice? These are all the things that you can set out to them that if they were to be made redundant, this is what that would look like. You have the first consultation meeting. You then, as I say, consider any ideas to avoid or reduce those numbers or mitigate their effects. So it may be that you can't afford 4 people working 5 days a week within that role, but you could afford 4 people working 4 days a week or 3 days a week. And maybe 2 of those people have already been considering dropping their hours, but they've just not mentioned it yet. That might be something that is possible. What the provisional selection of employees is, you need to, as I say, set out the selection criteria, what you're going to be assessed against, and consider, again, within the second consultation meeting, further consideration of any ideas to reduce or avoid redundancies. That final meeting, and that's why I would always recommend at least 2, so you can have the 2 consultations and then a decision, and that's when that decision will be communicated of, unfortunately, this role is redundant following that consultation, or you're no longer at risk and you will continue in your role. Whatever the outcome of that is, that will then be communicated after the consultation process. If I've not made it clear, as I say, these plan, document it, clearly plan where this is going to go, what we want, what we're going from and what we want it to look like, and who that will affect. That may become a critical document if this was to be tested and argued further down the line. If somebody was to argue that that's only taken place because they've been discriminated against, or it was a premeditated decision. If you can clearly evidence this was a plan affecting a number of different employees that would be placed at risk, this was the selection criteria, this is what we were planning to do, and this was what was undertaken, that's going to sit in very good stead to defend any arguments to say that you've been, gunning for one individual and that you have acted unfairly in that way. We need to be identifying appropriate selection pools. So is everybody in the selection pool? Probably not. Are we going department by department? What does that look like? And identifying proposed selection criteria. We are going to go into that slightly in the next couple of slides, what that looks like. As I say, there are a number of things on this slide. Some may be applicable to you, some may not. Some may be applicable to one redundancy process, but not the next one that you do. So it's all just going to be relevant to your specific needs and your specific criterias. So, selection. Who are we selecting? So I know I said before, and it is true, that it is the role that we are focusing on, the role that is placed at risk of redundancy. But generally, as I say, if we're taking that example of there are 4 people at risk and we need to reduce that to 2, how do we pick? How do we pick those 2? Don't particularly like you, and you were the last one we employed, so you're going to be the first one out. Is that going to be suitable? Is that going to be fair? Is that going to stand up in a tribunal? I don't know. Probably not. What we need to be looking at, as I say, is that fair selection criteria. So again, there's not going to be something that fits all for every redundancy situation that's going to be suitable across the board. But there are things that you can do to ensure that there is some consistency and fair, clear selection. It's clear criteria that employees can be marked against that aren't going to be, that are justifiable ultimately. So, performance. If you have previous performance appraisals, you've got one-to-ones, you've got employees that may have been on performance improvement plans or are currently on a performance improvement plan, should I say, these things may be taken into consideration. So anything that is clearly documented, clearly evidenced. So you can see, in all my one-to-ones that I've had with this company, I've got 5 out of 5. I've been over achieving. I've been marked as excellent. And if you're then coming at the bottom of a selection criteria for performance, there's going to be question marks over that. So that's something that if you have the written records of is a really good indicator and something that we would recommend using within the selection criteria. Attendance records is a potentially fair one to note because, again, clearly got it marked down. You've had this many absences in this amount of time, or you have had no absences in this amount of time. However, there is the potential for that to be indirectly discriminatory. So if somebody is pregnant or has a disability or an ongoing ill health matter, or they care for somebody within their family that has a potential disability, their attendance records may not be a true reflection. And then there will have to be ways that you mitigate that indirect discrimination arising from using that attendance record as a criteria. Again, I would recommend that you seek specific advice in that regard, because if you are going to use it, you can. I'm not saying you can't, but as I say, it does need to be applied in a certain way. Disciplinary records are a good one if somebody is on a final written warning, compared to somebody that has had no history of disciplinaries. You would, and I would only recommend using live disciplinary records and live warnings. If somebody had a first written warning 6 years ago that's no longer live at all, I wouldn't recommend that you take that into consideration. And it may be that you're looking at a team with no record of any disciplinary, so it's probably not going to be appropriate or necessary to use that as a selection criteria. Length of service, again, that used to be a really, really common one. I think it's not so much anymore. It can be considered indirectly discriminatory. A lot of parents who may have been out of work that have come back into work on an age basis, essentially, have not had enough time to build up as much length of service as you. And ultimately, I think even without looking at a legal slant on it, sometimes longer service does not mean better. You know, they may have more experience, but are they as up to date with relevant changes and relevant updates? That might not be the case. So you can use it, but I wouldn't recommend you use it on its own. If it is a case of everybody is coming in, really, really tight, and you're really, you have a level playing field across the board, but somebody's got 20 years service compared to somebody that's got 3, then in those circumstances, it may be appropriate. It is also completely legitimate for employers to attach weightings to criterias to reflect their importance to you. So if, for example, something is much, much more important to you in this particular area, that might be attributable to 30% of the overall mark or 25% of the overall mark. There may be some things, for example, if disciplinary record's really not that important to you, it might only make up 5% of the overall mark. You can have weightings as long as they are justifiable. As long as you can justify why that is important in that area, then that's completely fine. As I say, you don't need to shy away completely from subjective assessments altogether. What I wouldn't recommend is things that you completely cannot justify. So using attitude, for example, or I just don't like their attitude, but you've got no justification as to why that is. Why? Why don't you get on with them? Especially if that employee is the only woman or they have a long-term illness that's potentially a disability. That could be a really risky area. So they don't all have to be objective numerical data, but as long as there's a good mix in there, you can still use subjective assessments as well. So generally speaking, we would not recommend that any selection criteria is used in relation to any protected characteristic. So, we're going to get rid of the youngest members of staff. We're going to get rid of all the women. We're going to get rid of anyone that has that doesn't identify as being heterosexual. Those types of things clearly are going to be discriminatory. Hopefully, you don't need me to tell you that that is not something that we would recommend. But what you do need to be aware of is the indirect effect that certain selection criteria can have when you consider the protected characteristics alongside it. So there may be some things that you think, oh, that's absolutely fine, but does it directly affect somebody that has a protected characteristic and therefore is potentially unlawful? Part-time employees, we can't just get rid of anyone that's part-time. on the basis that they are part-time, that is potentially unlawful. And similarly with fixed-term employees, having a fixed-term contract, dependent upon what is in that contract, can be very misleading because I think a lot of people think at the end of that contract, they're done. I don't need to give any reason. See you later. But if that fixed term contract has been for the past 4 years, then they've still obtained the same employment rights as somebody who isn't on the fixed term contract that's been employed for 4 years. They've got more than 2 years service. You still need a fair reason to dismiss and to not continue with that fixed term contract or to extend it or to provide an additional one. There are a lot of nuances with fixed term employees. So again, if you have any specific questions in relation to them, it isn't something that I would be able to just give general advice over. We would have to review the contract itself. So I would always recommend that you do obtain advice in relation to that. And again, generally, anything that is too vague, best suited to needs of the business. What does that mean? What are the needs of the business and why are they best suited? General cost savings, anything that is too vague, as I say, attitude can be very ambiguous. We need to make it very clear. This is how we are assessing you. This is what we've used, and this is how we're justifying the outcome of our assessment within that selection criteria. And this is the outcome that we've come to. So there have been updates in terms of redundancy protection rights. And if you came to our conference last year, we also discussed it there. So this affects employees who are pregnant, on maternity leave, on shared parental leave, on adoption leave. I think that's it. And has an additional protected period of up to 18 months. So what that means is if somebody 18 months is the total. It's not in addition to their period of maternity leave. So from the date that the child is born, there is 18 months. So it may be that they take a full 12-month maternity leave, and then it's that additional 6 months upon their return that is this protected period. And this is where they have the right to be offered any suitable alternative vacancy if one is available. So that is a priority right over somebody that is not within this protected period. So somebody who is not pregnant, on maternity leave or on shared parental leave or on adoption leave or within 18 months after that start of the protection period. Okay. So that means that employers are obliged to offer them suitable alternative employment where it exists in priority to anyone else. Now, that doesn't mean that they need to just find a job. They just need to make a job up and put them in it because they're pregnant and we can't possibly dismiss them. That's not the case. But if, as I say, if we are reducing the workforce and there is a role here that you're all able to apply for, we're going to just go through the selection. We're just going to allow you to apply for it and we're going to interview and see where that would be suitable. If one of the people who are applying for that role are within that protected period, then they have the priority right. They are to be given that role essentially over somebody else. Okay. This is one of the only circumstances where this actually applies. But if you are looking at making any redundancies and any of your staff are to be considered within that protection period, again, please do seek advice before you start that process because it is one of the most up-to-date, newest changes within employment law, and it is a hot topic. So, solicitors are well up for running that kind of claim. So definitely keep an eye. And as I say, seek specific advice if you think there is a risk when you're undertaking such a process. So a suitable alternative vacancy. So work that is suitable and appropriate within the circumstances. So that, is all very circumstance dependent. So what is the terms of that employment? Is it a similar role? Is it completely different? If you had somebody working in the office and the alternative role is a forklift truck driver, it's probably not going to be a suitable alternative, but this is all very, very dependent upon the terms of that specific circumstance. So, as I say, it is a potentially fair reason. When we're looking at the calculations, so statutory redundancy pay calculations, there are numbers of things that affect that. So the three things really we need to know when we're looking at these calculations are the age. How old is this member of staff? What's their length of service? And that's in full years. So if they have 5 years and 9 months service, it would just be 5 years. We don't round up, we round down. Okay. And weekly wage. So what is their weekly wage? When you're looking at statutory calculations, that is currently capped at £700 per week. So if you're only looking at a statutory calculation and they earn more than £700 a week, then they would only be earning £700 a week. And similarly, the length of service is capped at 20 years as well. Check the contracts, check your policies, because if there is any contractual right to an enhanced redundancy over the statutory calculation, then these caps are unlikely to apply. Okay. But your general calculation is for anyone under the age of 22, you get half a week's pay per full year worked. For anyone between 22 and 40, you get a full week's wage. Sorry, I think that should say 41 actually, 22 and 41. That's my typo. And for anyone over the age of 41, you get a week and a half week's pay per full year worked. Again, that's capped at £700 per week, unless there is anything within your contracts that sets that out differently. Okay. So that's kind of a whistle-stop tour through the calculations. There is a government calculator, which is very, very helpful. And literally, Google calculate statutory redundancy. You can put the details in and it should give you an understanding as to what that looks like. Again, if you are unsure, either speak to payroll or speak to us, speak to your HR advisors. They should be able to give you an explanation as to what that calculation is and what that looks like. So, alternatives to redundancy. There are other cost-cutting options. And as I say, we're going to go into this in more depth within our conference. But generally, what you'd need to be considering prior to going through this redundancy is suspending any recruitment plans, a hiring freeze. We don't need any more staff. Clearly, we're looking at reducing our staffing levels. So we're not going to be looking at hiring within, people that have naturally left for other reasons. We're not replacing their roles. Looking at spending on agency staff and overtime costs, again, limiting overtime. Is it necessary? We're trying to justify why we need to reduce the staff when we're working the staff we do have. They're getting paid a much higher overtime rate. Does this make sense? Pay freezes, forms of flexible working. As I say, does anybody want to be reducing their hours anyway? Is that going to be something that they're going to be bringing to you as part of a discussion? Also looking at flexibility. I'm not saying to place everybody on an unpaid career break for a year. But if you have staff that have raised these issues and you think this is only going to be a temporary issue, potentially over the next 12 months, might be something worth considering. Or do you have the contractual right to look at short-time working or layoffs? This became very common in contracts post-pandemic because businesses didn't know what on earth was happening generally within the first few weeks. 5 years ago now, isn't it? So this is a contractual clause in a number of contracts, and it's certainly worth checking whether there are any within your contracts. And if they're not, do you need any assistance drafting those in? This may allow you to reduce your staffing levels temporarily. So they can be laid off for a temporary period of time, and the employees may be eligible for a statutory payment to be received from the government. So the government will pay a very small amount and they remain employed, but it's only for a very temporary amount of time, as I say. You need to be careful with these types of clauses because A, if they're not in the contract, you can't do it, and I wouldn't recommend enforcing it without the clause. But B, if it's for any longer than the 4 consecutive week period or a total of 6 weeks in a 13-week period, the employee can claim their redundancy. They can say, there's clearly no job for me here, I need my redundancy. And if that's what you're trying to avoid, then it's going to be a pointless exercise. So again, do have a look at your contractual rights and what you have and what you want to do. And if you do need any amendments, let us know. So very, very quickly, there is also settlement agreements. So this is something that we would recommend if you are looking at voluntary redundancy. So if before you've gone into any of the consultation process, if you've put a memo out to the team, we're considering redundancies, would anybody want to put their hand up for a voluntary redundancy? There may be some people that have been sat there years crossing their fingers that this is something you were going to offer and they've just been waiting for it. It isn't a dismissal, but it also isn't a resignation. It's a little bit of a grey area. So we would always recommend that this is done via a settlement agreement. These were formerly known as compromise agreements, and they are a legally binding contract which mutually terminates employment. So again, it covers that. It's not quite a dismissal, it's not quite a resignation, it's a mutual termination. There are often confidentiality clauses within there, so it is very much kept under wraps, and it sets out the payments due to the employee, generally with a compensation payment. So it may be that you will offer an enhanced redundancy if they sign this agreement, because it ends all legal claims against an employer. So, what we mean by that is if this is obviously, as I said at the beginning, sorry, I'll rephrase. This is a dismissal. Redundancy is a dismissal process, and a dismissal comes with risk. Employees have the right, when they have at least 2 years continuous service, to pursue a claim of unfair dismissal. So even if you do everything right, as you should have done throughout that process, there is a risk at the end of that, because you have ultimately dismissed somebody, that they could pursue a claim to the employment tribunal. What a settlement agreement does is ensure that that risk is completely quashed. And this is probably the only time we can guarantee that there will be no claims brought. As I say, the whole point of a process like this is to mitigate the risk of a tribunal claim and to look to prepare any kind of defence should it be necessary. But we can never guarantee, even in the nicest of circumstances, that somebody isn't going to go change their mind and decide to pursue a claim to the employment tribunal. In a settlement agreement, this prohibits them from pursuing any further claims. So generally, you will pay an enhanced figure to compensate them for losing that statutory right that they have to pursue those claims. Okay? So it is the only, as I say, time that we can guarantee no claims were going to be brought, but it will cost you a little bit more in the forefront because you're paying that enhancement. So why use it? As I say, it ends nearly all ongoing and potential legal claims. So if you are going down a normal process or in any other capacity of dismissal and you think this is a bit risky now, we've kind of missed a few steps in this process. We had a rogue manager hold the first consultation meeting and he said some things he really shouldn't have said. It's all getting a little bit nervous. Do you want to consider offering a settlement agreement? Is it something that you need to discuss with a legal advisor, one of us in our team? Is it going to be necessary to have that conversation? It will end, as I say, those claims. It does help them going through this process, and it also means that if you if it is deemed that a process is too onerous and it isn't going to be possible to be undertaken, in using a settlement agreement, if the employee agrees to it, then you don't have to go through the full process because they have forfeited their rights to pursue any claims for the fact that you didn't. So again, it can cut the process shorter, but you will be paying more of an upfront cost in terms of an enhanced payment. It sets out a clear plan to the termination date. So we can have clauses within a settlement agreement that set out, okay, you're going to work until this date, and then you're going to be on garden leave until this date, and you're going to return all your company property on this date, and these are the things that are going to happen. So it's very clear to all parties how that's going to go. There are confidentiality and ultimately gagging clauses within there. So there are things, non-derogatory clauses. You're not going to badmouth us. We're not going to badmouth you. There's a much more limited risk there. As I say, for voluntary redundancy, we would always recommend that you use a settlement agreement because it is very clear how this termination of employment has come about, rather than, is it a dismissal? Is it a resignation? They force me to put my hand up for voluntary redundancy. It can get a little bit messy without one. It can avoid processes such as grievances, disciplinaries, redundancy, performance management, etc., and end relationships amicably, ultimately. Now, this is very much a whistle-stop tour over settlement agreements, and it is not something that I would recommend you just start dishing out here, there, and everywhere. There are ways and means by which you can make offers of settlement, and it only in limited circumstances. So again, if you are unsure, please do seek advice. There are also things that cannot be settled by a settlement agreement. So we can't have complete control over what is discussed with the employee. So they can still discuss matters with regulators. They can report to the police, to HMRC. They must discuss with their legal advisor the terms of the agreement. Anyone else who is bound by an obligation of confidentiality. But if they need to disclose a criminal offence or a tax issue, that is something that cannot be contracted out of. Claims in regards to their pension cannot be contracted out of. Certain PI claims, as I say, protected disclosures, certain statutory payments can't be contracted out of. So there are certain things, and if your aim is to prohibit claims being brought under some of these headings, then a settlement agreement is not going to be the best course of action for you. And again, we would always recommend that you seek advice before an offer of settlement is made, before any without prejudice conversations are had, and before you pay to have an agreement drafted. We need to know the circumstances as to whether this will achieve what you are wanting it to achieve. But generally, it is a much, much safer way of terminating somebody's employment if it is generally high risk. So the last point that we wanted to cover really is maintaining employee well-being. So as I say, there are a number of things to consider when you are placing somebody at risk. It may be that you are placing 30 people at risk. Only 10 of them are going to be made redundant, but those 30 people and the 20 that are coming back to work could be, severely impacted in terms of their physical and mental well-being. So is there any EAPs that you can signpost them to? Is there anything that you can do to alleviate their concerns? And I'm not saying, when they're in the toilet, go, don't worry, you won't be made redundant. We've made sure who's going. Nothing like that. But if there is, as I say, any support, and just if you are a manager, if you are a HR manager, if you are running this type of process, being as transparent and as open as you can, and as you are allowed to be, is really going to alleviate a lot of people's concerns because they're less likely to feel like you're hiding something, you're trying to cheat them out of something. They're going to be less suspicious because you are laying the cards on the table. This is the situation. This is why we're looking at making redundancies. These are the alternatives that we've considered. We're willing to listen to you. What do you think? And they're going to feel a lot more heard and a lot more supported, which I find generally works wonders in terms of employee well-being. Mitigating the negative effects of redundancies. So once you've gone through that process, there may be, scars left behind. People are still going to be on edge. Are we all right? Is the company going to close? Was that enough? Might be worth looking at organizational goals and priorities moving forward. Okay, we're revisiting where we are as a company, where we want to be, what our values are, what's our mission now. We're going to refocus, and this year, this is what we're going to go for. It's going to bring everybody back together and feel a lot more secure in that role that they've potentially just had to reapply for or go through a full selection criteria. It's going to make sure everybody is back on track on the same page. Again, with developing that clear plan for those desired outcomes, that can be on an individual basis or generally a company-wide approach. Communication. Communication is the key thing for me in this. In going through the consultation process and afterwards, make sure you have clear lines of communication every step of the way with transparency and empathy and, a clear understanding that this is going to be impactful on everybody affected. So we've come to the end, and I do apologise. I have kind of whizzed through the last few slides because I'm just very conscious of the time and that a lot of you will be going back to your desks after spending your lunch break with me. So thank you very much. But we will also be sending out feedback forms. We'd really appreciate it if you have the time to fill in any of the feedback forms that are sent to you. And if it feels appropriate, then to leave a review. But I also wanted to check in to see if there were any questions. I do think we have two in the Q&A, so I will cover those if people have the time to stick around. So I've got, can a recruitment freeze be avoided for special skills or if you need a role filling that cannot be filled by upskilling existing teams? Generally, if it's justifiable and there is a specific need and a specific role that is unaffected, then yes. If it's a business need, then absolutely. However, if there is anybody affected that in any way could have those skills or that experience to fill that role, it's always worth bringing it up in the consultation and at least highlighting the fact that, look, we've got a recruitment freeze generally, but this is a role we really need to recruit for. Do you think you would be interested if it's anywhere close to anything that they do? Always worth raising it. And secondly, what if you haven't documented a performance or attendance issue? Can the issues be taken into account? That is very, very common that people don't document the issue. I would always recommend that where possible, it is documented because it is going to be very difficult to rely on it otherwise. If it ultimately turns into a he said, she said of, I've told you about this before. No, you didn't. I thought it was fine. That was never mentioned. It gets very messy. So where possible, always document it. And if not, it's going to be one of those that you need to take a view. If it's very clear that the employee also acknowledges and appreciates that there is something that has been raised before, then you might be on safer ground. But that's going to be a case of your employees better. So you may want to take a view. Oh, and I've just got one more. Thank you. So we're about to release voluntary redundancy as an option. Yeah, was mentioned as next steps for our organisation 4 weeks ago. Yesterday, an employee handed in their notice. Do they forego their right to voluntary redundancy and applying for that? Technically, yes. If they've not gone through the redundancy process and they're just resigning, then yeah, there's no obligation to make them redundant. There's no obligation to provide a payment. You might want to take a view internally whether you would want to offer them voluntary redundancy because technically you don't have to if they're already going. They may feel slightly aggrieved by that, but they're not remaining as members of staff that are going to continue working. So a decision needs to be made upon their employment as they would be if they hadn't resigned. It's not pleasant, is it? But technically the answer is they don't need to be made redundant and offered voluntary if they're already going. All right, I hope that's been helpful. And as I say, if there are any further questions, oh, I've just lost my screen. I'm not sure. Oh, no, there we are. If there are any further questions, please do email us. As I say, all these slides that I'm just flicking through now, if you're interested in any of them, the slides can be sent to you. You can have a look at these all in detail. But generally, the big headlines really, as I say, are if you do want any more in-depth advice or any specific questions, drop us an email or come along to our annual conference that is being held, as I say, on the 13th of March. It is at the Doubletree by Hilton at Bramall Lane, so not far from our office. And if any of you are local Sheffield, hopefully you know where Bramall Lane is. For those of you that feel comfortable to go, if you're from the other side of the city, then do please buy a ticket and I would love to see you there. Otherwise, we have further HR exchanges online or our exchange meetups in person. We've got a couple of those coming throughout the year. So any questions about any of those or how to book on or where they are, please do let us know. And if any of you have got your phone sat at the side of you, you can sign up to our monthly newsletter using the QR code that is currently on the screen. So I will leave that up for you. Thank you, everybody that's come online today. Thank you for your questions. And then, as I say, if there's anything else at all, drop us an email or you can pop it in the feedback forms. All right. Thanks ever so much, guys. I'm going to stick around online for a few more minutes, but I will